This is SJC-13281, Matthew London Davis v. Commonwealth.
Okay, Attorney Spurlock, good afternoon.
Good afternoon. May it please the court, Matt Spurlock for Mr. Davis. This is the second time that the sufficiency of the evidence in this prosecution is before this court. And last time around, as this court knows, it considered the untested and unreliable GPS speed evidence in the analysis. And even with that speed evidence, which turned out to be inadmissible, the court noted that the Commonwealth's case was not by any means overwhelming. The evidence at the second trial, where the jury could not reach a verdict, was substantially weaker for the Commonwealth. It was only the GPS speed evidence that was the common thread tying together the disparate and equivocal circumstantial evidence in this case, allowing a minimally coherent narrative. But without the GPS speed evidence, all that is left is mere presence. And no rational jury could conclude beyond a reasonable doubt that Mr. Davis was the shooter in the grainy surveillance video of a video. Or
but there wasn't anything conclusive. That's I'll give you that. That's fair. But there were a variety of bricks to their wall, right? Where you had the surveillance video with the general description, particularly of the red sweatshirt. You had, and you add the bricks of the witness who the perpetrator allegedly ran by. You have the GPS coordinates, which were properly admitted, that showed the defendant from the area in which the shooting happened all the way back to his home. Even later, about, I think the execution on the warrant was like a week later, they still found the sweatshirt. Why do you say that all of those bricks can't lead to the identification of the defendant as the perpetrator?
Your Honor, I think the court's opinion in the last case is instructive on all of those points, but take them in order. Starting with the
our last decision said it may not be the strongest case for the Commonwealth. It wasn't opining on the sufficiency of the identification.
I agree, Your Honor, but at every point it discussed the importance of the speed evidence in making each of the points that you just discussed probative at all. So let's start with the surveillance video. So this court said that the surveillance video was not probative of ID at all. It was probative of the intent of the shooter to kill. That was probative. But in terms of, we have a generic description of a black man with mid-back length hair. That's all the video shows. So in terms of probativeness for ID, there's simply nothing there.
You've got to couple that with the time, because it was mid-morning, right? So it's not just it's not a situation where there were a variety of people that fit that description, that generalized description, on the street at the time. There was a specific testimony by the witness who was there with 2 other people or 3 other people who recognized, and granted, I give you that she didn't make a positive out-of-court identification, but all of those things plus ending up at his home, I just don't, I'm struggling to see why that isn't enough. Granted, even with the fact that this jury might have been deadlocked on it, why a jury couldn't find the identification made.
So, Your Honor, there's nothing incriminating about being in that location in the mid-morning, and there's nothing incriminating about going home after a gunshot occurs, especially if you have a GPS on you. I mean, I think we want people to go home. So, those are certainly not something that the jury could use to find identity beyond a reasonable doubt. In terms of Ms. Rock, I'd like to point out that she had a negative ID. It wasn't just that, she couldn't identify them. She said, it's not him. I don't think so. Moreover, the only thing that this court said last time, on top of the negative ID, they said would not preclude the inference that this person that she saw was Mr. Davis was the speed. And we simply don't have that here, because she testified, and this is at volume 1, page 62, that she saw one runner while she was out there on the corner of Columbia Road, major artery, in the mid-morning. She's out there with a group of her colleagues. There's no testimony at all about who else may have been there in that neighborhood. We have evidence before the jury that that's a majority black neighborhood. We have evidence before the jury that many black men have long hair and braids or dreadlocks. So, this ID of Ms. Rock not only is a negative ID, but the only thing in this court's word, that would not have precluded overcoming that negative ID is gone. So that's what this court said last time, and I think that is well taken, and it goes to show that the threat of the speed really was necessary to draw an inference beyond the reasonable doubt. And I think when you look at some of the other cases that have, mere location, mere presence is what we're left with. So let's look at some of the other cases that discuss that. Maza was a case that this court distinguished in its last opinion because there was a presence issue there. But on top of that, you had a motive, consciousness of guilt, and even then, not sufficient to convict. Just a couple weeks ago, this court decided a case, Kapaya, I don't know if I'm pronouncing it correctly, but you also had GPS evidence there, but in that case, you had an admission, you had a positive ID, you had a motive, you had consciousness of guilt. All of these things are missing from this case. So, on the Commonwealth's view of this case, the upshot of this is that anytime someone wearing a GPS is in the vicinity of a crime, that is going to be good enough without more, without consciousness of guilt, without motive, without any forensic evidence, and indeed in the face of negative ID. And that is just not the law. I mean, it's clearly would be precluded by what this court said in Davis 1. So
it's important to keep in mind, though, that in Davis, we were analyzing whether or not there was a substantial risk of miscarriage of justice. Obviously, there was a sufficiency issue, and we can include the speed in the sufficiency issue, but the discussion about other evidence was within the context of a substantial risk of miscarriage of justice.
Your Honor, you wrote that decision, so you know it better than I do, but I have read it many times. And what I will say is that as I read it, those discussions are melded into one. So the part that deals with sufficiency, there's an infra that refers to this court's discussion in the prejudicial error section. Mm-hmm. And at every point, you talk about the three principal bases for the sufficiency evidence. That's the video, and that's the eyewitness ID, and that's the GPS location. At every point, the court, in the sufficiency section, emphasizes the importance, the necessary importance of the speed evidence. And it says it's not going to comment on, what could happen in the next trial, but it emphasizes the importance of that. That's how it distinguishes Maza. That's how the court says, we're going to allow that the jury could infer that this was the same person because the speed, because Ms. Rock saw one person running and the speed showed that the person wearing the GPS was running.
Yeah, those are all fair points. What I'm saying is that the speed issue we determined didn't satisfy Dobert-Lanigan.
Sure.
So what we had to do is we have the speed, it factors into the required finding, and we have to analyze whether or not it's a required finding or not. And so we find that the evidence is sufficient, but then we have to consider all the evidence and whether there was a substantial risk of miscarriage of justice, and that's the prism. So the evidence has to, I understand, has to be considered with both, but we're not analyzing that to say that it would be double jeopardy to retry it.
Absolutely agree, Your Honor. You state very clearly in that opinion that you are including speed in the sufficiency analysis. That's what I started my presentation with, the last time you had speed. As I read that opinion, and we can even take out that opinion, as I see the evidence now, speed is the crucial link that ties the other circumstantial evidence together. And so without speed, and that is discussed in each of those three paragraphs, the three paragraphs in the sufficiency section, I'm not talking about the prejudicial error section, in the sufficiency section, and speed is crucial. Speed is crucial to allow an inference that Ms. Rock, over the negative ID, that Mr. Davis was the runner. Speed was crucial to show that it was indeed him in that grainy video, which this court said could not result in any identification. In terms of the red sweatshirt, what Justice Georges asked about, I don't think there's anything incriminating about having a red sweatshirt. There was no testimony that Mr. Davis was wearing a red sweatshirt on September 15th. The fact that a young man in Boston has a red sweatshirt in his bedroom, I think, is neither here nor there. I will say that they did test it for gunshot residue and it came back negative. So, I mean, I don't think that does anything either way. I see my time is up. If there are any other questions, I'm happy to answer them.
All set. Thank you.
Thank you very much.
Okay.
Good morning or possibly afternoon. May it please the court. Ian McLean on behalf of the Commonwealth. Here, viewed in the light most favorable to the Commonwealth, there was, through a combination of multiple pieces of circumstantial evidence, along with the reasonable and possible inferences therefrom, there was sufficient.
There are, but as Attorney Spurlock just mentioned, isn't the tie that binds speed? And
respectfully,
without
no,
speed, there's no mortar between these bricks?
Respectfully, no, Your Honor. I think there's plenty of mortar within the bricks, and you'd find that at Exhibit 23, which is Defense Appendix page 27. That's the map of the area. When you look at that map and you put the times when he was at each of the locations he was, 10:27 at the corner of Quincy and Baker, the next minute at the corner of Baker and Bodwell, the next minute after that he had made it back to Columbia Road. You can see the distance that he traveled in that time, and any juror can look at that and estimate roughly how quickly he was moving. So while GPS speed evidence was introduced in the first trial, I don't see it as in any way essential in the case. It's an inference a jury could draw based on their own life experience themselves. As to the bricks in the wall that you referred to, Justice George, I think one was sort of left out in the prior discussion.
Could you summarize those for us, just the different pieces of evidence?
Sure, Your Honor. I'd break it down into 5 sort of categories. One is the GPS points themselves. 2, the video clip itself showing the shooting. 3, the witness on a block and a half away, Irene Rock, and what she saw run by her. 4, the defendant's appearance, his actual appearance as the court saw when he was there at trial and as his probation officer testified to, and the existence of the red sweatshirt. So I take those 5 pieces and you put those 5 pieces together and it builds a solid wall. And some of that mortar between those bricks that we were talking about, the significant piece that wasn't discussed, if you look at the video clip, Exhibit 48, which you have, the shooter fires with his right hand. The witness, about a minute and a half, 2 minutes later, testified that she saw the person run by her with his right hand tucked into his sweatshirt or his pants pocket. That's further indication the person that she saw run by her, as opposing counsel pointed out, the only person she saw run by was the shooter. Then you compare that against the defendant's GPS points, and it's the same path that he traveled and then continued on from there to his residence, as you pointed out, sir. So you put those pieces together, that provides a mortar between each of those bricks, establishing a solid wall here. The other things that I would point to, the person itself that you see in the video footage. I mean, it's not a great security video footage, but it's clear enough that it's a red sweatshirt and that it is a young black male, thin, tall male, with hair. You can't necessarily tell if they're braids or dreadlocks, but they're long and thin. And I would disagree with opposing counsel's characterization that the hair went to the mid-back. I would say from looking at the video that the hair is beyond the shoulder length, but I don't think classifying it's going all the way to the middle of his back is a fair inference from that video. But you look at that video itself, draw the picture that you see of that person, and then compare it to the testimony that Irene Rock provided from a block and a half away of the man she saw sprint by her. She described him as a tall, thin black male wearing a red sweatshirt with hair in thin braids pulled back into a ponytail, and the hand in the pocket or the pants, the same hand that the shooter used to fire the weapon. That's the same person that she saw run by. That same person lines up with the defendant's GPS points from the intersection where the shooting occurred up past Irene and then to his house. The reasonable and possible inferences from that, those pieces together, are that the defendant was the shooter here. So the Commonwealth presented sufficient evidence when you look at it in the light most favorable to the Commonwealth and you draw those reasonable and possible inferences, none of which have to be necessary or inescapable, just reasonable and possible.
And this is not piling inference upon inference because?
Respectfully, Your Honor, from each set of a couple of individual facts, you draw an inference. And then from another set of a couple of individual facts, you draw an inference. The inferences are not built
They're
inference
not built
upon
on each
inference.
other. Okay. And so what's the evidence of, I mean, you've linked the GPS to the defendant, but how did that get linked?
I'm not sure.
I mean, how do we know that this is the GPS? I mean, how, did he have his phone on him or?
Oh, he was on a GPS tracker device as a result of a
Oh,
federal
that-
case.
Okay.
And in the retrial, the witness that testified about that in the initial trial, his testimony was read back to the jury in a redacted form to eliminate any references to speed that this court had reversed the prior conviction on the basis of.